Hello everyone, welcome to this first session of SCL Talks. I am Sergeant Plaksoğulları. I am the Secretary General of SCL Turkey. In these SCL Talks sessions, we will be discussing construction law topics with our esteemed guests, and we hope that you will have some takes from these discussions. In this first session, as our guest, we have Scott Stiegler, one of the partners of the International Construction Disputes Division of Vinson Elkins Office in London. So welcome, Scott. It's great to see you.
Likewise, good to see you again.
Thank you very much. So as an overview of our discussion, as you may know, disputes, whether large or small, disputes are a common feature of construction projects. And there are many factors that give rise to and then influence the ultimate form of a dispute. So the anatomy of a construction dispute is complex, and there are many sides to it. There's no single paradigm within which a construction dispute exists. So the purpose of our discussion is to briefly explore the life cycle of a typical construction dispute from inception to conclusion. So Scott, the floor is yours.
Thank you. We'll start from the very beginning about the identification of a potential dispute. So construction projects are associated with considerably more risk than typical commercial transactions, both in terms of the type and nature of risks involved and the complexity of those risks. There are many possible ingredients to a construction dispute, with the proportions and the mixing of those ingredients defining the scope of the dispute. Carrying on with the theme, common ingredients in no particular order will include firstly, the form of the contract and how risk and responsibility is shared or is allocated. Secondly, the parties, along with their backgrounds and experiences in the industry and with one another. Thirdly, the length of the project, which may change the likelihood of risks occurring, for example, such as weather events, currency or price fluctuations, political risks and the like. Events which put pressure on contractors' programs, such as delays in approvals and in inspections, unforeseen events, change orders, and other usual events that you can commonly associate with delay to the ordinary progress of the works, and errors and omissions in parties' understanding of the scope of works, which can either be errors in a contractor's tender or in an owner's scope of works, design, technical requirements, but also ultimately the execution of the works themselves. And finally, the occurrence of external risks such as force majeure, changes of law, and the like. This is by no means an exhaustive list. And while these matters may be the initial breeding grounds of the dispute, the legal and contractual framework within which the parties operate will often dictate how the dispute grows and whether it will grow into something more significant. For example, events which increase the contractor's cost are more likely to be escalated for resolution in a lump sum contracting arrangement when compared to those in a reimbursable contracting arrangement, for example. Furthermore, the impact of external factors, which significantly impact the contractual balance between the two contracting parties, may be treated differently whether the contract is governed by the laws of a common law nation or a civil law nation. So consequently, while there are a number of hallmarks of matters that may give rise to a dispute, there is no single recipe. Dealing with construction disputes when they begin to materialize. Whilst there will be many techniques in approaching a potential dispute, we really see three issues sitting at the core of effective and proactive dispute management. These are, firstly, good knowledge of the provisions of the contract. Secondly, effective communication. And thirdly, keeping records. Firstly, before one knows whether or not there is going to be a dispute, one must know the provisions of the contract. Whilst construction contracts generally contain the same types of provisions, no two contracts are the same. And essentially, the contract is the project's rulebook.
So I guess you would agree that contracts need to be really known by all the parties by heart, and really it's not meant to put the contract in a drawer and then it's to only remember it when a dispute arises, right?
Absolutely, and it's those projects where the project manager has put the contract in the drawer are the ones that I see later down the lines in a full-blown arbitration or court proceeding. So that's exactly right. Taking that theme, perhaps early on, the most important provisions are those that relate to notice. Notice provisions are designed to benefit both parties. So, for example, they allow contractors to give timely notice of issues to, amongst other things, preserve their rights, to make a claim, or to seek additional compensation. But they also allow owners to consider timeously the issues that are raised and to take proactive steps to address the issues that are being notified. So from our perspective, understanding the notice provision is crucial, as it's common practice for notice provisions to be described as a condition precedent, which means that notice provisions must be satisfied before entitlement can arise. And so therefore, misunderstanding notice provisions by, for example, giving a notice too late or in the wrong format could imperil entitlement to a claim.
So does this also depend whether it's a civil law country or a common law country?
Sometimes yes and sometimes no. English law is certainly well established, but there may be differing interpretations under civil law, depending if it has a provision which, you know, contemplates following the black letters of the contract. It depends, and there'll be different nuances in different jurisdictions, and, you know, perhaps something we can do in another talk. Secondly, is effective communication. Projects are busy, and everyday challenges can mean that effective communication is sacrificed to gain time, or because of the need to reduce increasing workloads. However, effective communication is essential to every phase of a construction project, not just to when a dispute starts to materialize. Poor communication can result in further misunderstandings, delays, or other issues, as well as potentially escalating a dispute. So it is essential in our view to communicate plainly, to be objective, factual, professional, and to be complete with communication so as to avoid any misunderstandings or later reinterpretation of what was said contemporaneously. The importance of communication is simple. Good communication can improve teamwork and lead to better project collaboration, and ought to avoid or at least mitigate the effect of a potential dispute. Poor communication can result in misunderstandings, delays, and other issues that may in itself exacerbate a potential dispute.
So I definitely agree this with experience, but my question is, I guess expediting communication should not really sacrifice or end up having poor contemporaneous records, correct?
Absolutely correct. And from a litigator's point of view, a document cannot talk back to you. A document says what it says on the face. So having good contemporaneous records is absolutely key, which leads nicely into the third point, which is good record keeping. Accurate records often make the difference between whether an issue escalates into a dispute, and if it does, whether the case is won or lost. Good record keeping is about discipline. It's a bit boring, but it's an important task. So at the outset of a project, we would say it's prudent to establish a framework for document collection and retention, which sets out the types of records that would be collected, who is responsible for collecting them, and where they will be stored. And what might seem like a tedious task will definitely pay dividends should you find yourself in a dispute, which could be long, laborious, and costly further down the line. And so into the final topic, which is formal disputes. In the first instance, a dispute will typically start with a written notice or a claim from a contractor, followed by a response or a determination from an owner. These early exchanges are really important as they set the groundwork and indeed sort of set the procedural parameters of a dispute, and will underpin the steps that will happen next. From a contractor's perspective, they must carefully describe the full parameters of the dispute in order to avoid possible later challenges about the scope. For example, in circumstances where a later dispute covers a broader set of factual matters than those the subject of early exchanges, in a notice, for example, there could be challenges in the form of a jurisdictional challenge, or indeed challenges to entitlement on the basis of, an initial notice didn't cover the full scope of what the contractor is saying that the claim covers now. from an owner's perspective, they will want to ensure as much precision and clarity as possible. Therefore, an owner may want to seek further particulars of a claim in order to understand its scope and its nature. And so a level of precision is required, and interrogation is required in these initial exchanges. This exchange of correspondence may transpire over a period of months. Sometimes it could be years. It really depends. But from this point, there are a variety of possible options depending on the contractual and legal framework within which the parties operate.
So at this point, I have one question. So as you may know, some parties sometimes prefer to settle their disputes or handle some of the claim issues, etc., towards the end of the projects because they simply adopt a wait-and-see approach. So what do you think about this?
So it really depends on the claim. Personally, I would advocate for an approach which seeks to make the claims contemporaneously when the events are fresh and things are moving, and typically this would generally result in a more amicable solution because parties are working together. The wait and see approach can bring additional clarity if it's done properly, but in my experience, the wait and see approach also brings with it a tendency to try and recreate history. So it really depends on the parties, but it can go both ways. So in terms of hearing a construction dispute, it can come in many forums, and not just formal forums like court and arbitration proceedings, but informally through senior executive meetings and the like. Many construction contracts contemplate multi-tiered dispute resolution, where the parties must progress through a number of tiers of resolution options in order to reach ultimately the final and binding outcome. So beyond the exchange of the claims between the owner and contractor, common steps can include executive level meetings or sponsor level meetings. And these can be particularly useful if the project teams are entrenched in their respective positions and a bit of clarity is needed and perhaps some commercial perspective is needed from that higher level. Expert determination is another option, which involves an independent expert reviewing and providing usually a non-binding opinion on a particular issue. And it's particularly prominent in technically specialized contracts, such as in rail disputes. Another common step is dispute adjudication or dispute resolution boards. These are generally features of larger projects, and they are highly customizable, but often operate as essentially a truncated formal dispute resolution process, with many of the usual formalities being removed, such as document production and cross-examination, for example. And also there's obviously mediation, which is conducted in a structured environment with a professional mediator. And it's usual for parties to exchange position papers ahead of the mediation. And in some cases, the parties may agree to obtain an independent non-binding opinion from a technical expert or a lawyer if there is a key issue, legal or technical, which is dividing the parties, to try and use that to secure an amicable solution. Typically, you'd find one, sometimes two of these steps before any formal court or arbitration process commences. And generally, the timeline for these steps can vary. It could, generally within the region of a year, but it could be possibly longer for example, for more complex DAB disputes, for example. The construction contract will almost in all cases specify the final resolution form, whether that's courts of a particular jurisdiction or arbitration.
So when talking about courts and arbitration, is there any data available for timelines comparison of timelines between arbitration and courts, or what's your experience on this?
In terms of timelines, it's variable. Arbitration can be longer, court can sometimes be longer. A typical arbitration will run for a couple of years. A court proceeding will generally run for a couple of years as well. It's just, again, it depends on the complexity of the dispute, really. and how efficient the courts are. The English courts are reasonably efficient with construction disputes, but some other local courts may not be so sophisticated.
So that's the complexities of both on parts of legal parts and also the technical parts as well, I assume.
Absolutely, absolutely. Taking that theme, a common final form is arbitration, and construction arbitrations follow the same structure as general commercial arbitrations, but generally entail more technical issues, such as larger amounts of evidence, and often have a series of claims and counterclaims. Because there's a variety of options when it comes to arbitration, it would be usual for the contract to specify things like the governing procedural rules, the seat of the arbitration, the number of the arbitrators, and if there's any requirement on qualifications or restrictions, and whether there's any specific evidential rules that are going to apply, such as the RBA rules and taking evidence, for example. So following the preliminary exchanges, which establishes the terms of reference for the dispute and establishes the panel, a typical arbitration will involve the exchange of detailed written submissions, witness statements, expert evidence, and supporting documents. And within the overall process is document production, where the parties are required to search for and produce documents, although this process is not as broad as what you would expect in the English court proceedings, for example, in their disclosure process. Following the exchange of pleadings and document productions will be the merits hearing. And again, depending on the issues, hearings can range from a week or two to anything beyond. And in large disputes, it may be that there are multiple hearings themselves covering 6 to 8 periods, for example. 6 to 8 weeks. It would be usual for witnesses and experts to be cross-examined by the opposing party, and the tribunal itself may want to ask questions, and that's particularly so when you have either a contract that's governed by a civil law, or you have arbitrators who are from a civil law background. They tend to be more inquisitorial. So from inception, a duration could typically be anywhere from 1.5 to 2 years to several years. And it could be much longer where there are initial jurisdictional challenges or changes in the usual procedural structure, such as consolidation or bifurcation. And this is where arbitration tends to distinguish itself from court proceedings a little bit more in terms of time. As we touched upon briefly, a distinguishing factor in construction disputes is the need for technical evidence, whether on matters of delay, quantum, or other scientific or engineering discipline. And a perceived problem that does arise through the use of party-appointed experts is that the expert evidence usually just supports either side's respective cases. And so the tribunal is faced with divergent opinions. So one option we have used successfully is to require the parties' experts to confer and to ultimately to issue a joint report setting out their respective points of agreement or disagreement. And this may be useful because generally the technical evidence will dominate a significant portion of a construction dispute.
Yes.
Another distinguishing factor is the significant volumes of technical and commercial documentation of data. And the consequence of this is document production itself gains a particularly significant importance. And unfortunately, it becomes quite a costly part of the overall arbitration. So good planning and efficient management of the document production process is key. And linking back to where we began with this is the participants in a construction project must remain vigilant of the possibility of needing to appear as a factual witness. How a person participates in a project, how they communicate, and how they deal with the project participants will likely feature in a later dispute if that person has had a central role in the factual circumstances giving rise to the dispute. So at the core of this is essentially that all construction disputes will be governed by the parties' contract. Therefore, the key takeaway is to ensure that your contract deals with not only how disputes will ultimately be resolved, but also how they'll be handled when they begin to arise during the course of the works.
So do you think, in summary, do you think it would be beneficial for or helpful for the project teams, especially to team up with, especially contract management people plus the legal teams from the beginning of the projects, so that they can at least attempt to avoid these disputes as much as possible?
Absolutely. Having clarity at least on the parameters and structures of how the parties handle disputes, how they wish that relationship to be governed during the works as well as after, it is absolutely essential. And very early on, it's not just your EPC lawyers you want involved. You want to have the insight from your claims team and your dispute lawyers as well, advising on their experiences on things that work and things that don't work. So ultimately, the parties have a clear rule book on how they handle their disputes going forward, right from the very beginning.
That's correct. Right. Thank you very much, Scott. You have really very clearly summarized the anatomy of a construction dispute in this time we have available for this session. Thank you very much again.
My pleasure. Thank you for having me.
Thank you. So this concludes our first session of SCL Talks. So hopefully you have enjoyed our discussion and you have your takes on the subject. So we hope to see you again in our next session. Thank you very much and goodbye.